If your case has been set for a preliminary hearing, there are several things that may or may not happen, certainly depending on what county you're in, what court you're in, and what jurisdiction you're in. For instance, you may be set for a preliminary hearing in federal court. The first thing you need to know about any preliminary hearing is that it is not a trial of your case. It is simply an opportunity for the government or the state to present evidence to a judge. The judge does not determine innocent or guilt. The judge simply determines whether or not there is probable cause to proceed with charges against you. The benefit for the defendant is that the defendant is able to review some of the evidence that may be used against the defendant later on. At the preliminary hearing stage, you are not entitled to discovery, so you don't get to review police reports or recorded interviews. What you do get to do is ask questions of one of the accusers. However, in federal court, usually that accuser is nothing more than a detective. And the detective is simply going to read a police report at the hearing, and the judge always, without question, will find probable cause. So a preliminary hearing in federal court is actually fairly useless. You're generally better off waiving it, because the sooner you waive it, the sooner you'll get an indictment from the prosecution, and the sooner you'll have access to that actual evidence against you so that we can figure out if they have enough evidence to convict or whether or not we should be negotiating some sort of plea agreement. So generally in federal court, a preliminary hearing is not a necessity. In state court, they can be useful if you get them, and unfortunately, usually you don't. In Cuyahoga County, in Lorain County, and most of the surrounding counties, if you're set for a preliminary hearing and you demand it and you want to do it, you still may not get it. It's not a requirement. There's a loophole in the system. So if a municipal court has set the case for a preliminary hearing, it's the same reason for federal court, but there's a bit of an additional reason why they have to do it. Preliminary hearings are always conducted in municipal courts. The reason for that is that a municipal court does not have jurisdiction over a felony. They can't handle a felony case, even though the cases often start there. So if you have a felony drug case in a municipal court, that court doesn't have jurisdiction. And all they're trying to do is to figure out how they can get it off of their docket and onto the county court, which handles felonies. They can do that in multiple ways. One, they can ask you to waive the preliminary hearing, which if you do, the case is bound over. Another way they can do it is they can conduct a preliminary hearing. And again, they'll present one or more witnesses to a judge, and the judge will determine whether or not there is probable cause to move forward with the hearing. That's the only instance where you actually have witnesses that you can cross-examine. But again, it's not every witness. It's usually only one or two at the most. And those witnesses often aren't particularly pertinent to the case, so you really don't get a lot of evidence from those hearings. Sometimes you do. I'll explain later. The third thing that the municipal court can do is that the prosecutor can simply move to dismiss the case, which you think is great, right? My case got dismissed. I win. Wrong. All that means is that the case was dismissed out of the municipal court. The evidence was passed over to the county court. That county court prosecutor then presents the case to a grand jury and you get indicted. So all that was dismissed was a case in a municipal court which never had jurisdiction over your case in the first place and sent over to the county court for full prosecution. So oftentimes when you demand your preliminary hearing, the prosecution simply dismisses before the hearing occurs, and that way your attorney never has an opportunity to cross-examine any witnesses. In those circumstances, your bond will generally be higher and your attorney won't have access to any of the evidence. If you waive a preliminary hearing, however, there's a good chance your bond will get lowered, and there's a good chance the city prosecutor will maybe give the defense attorney at least a police report or some preliminary evidence so that you have a better idea of what it is you're going to be facing when the case finally gets over to the county. The last thing a city prosecutor might do is simply ask for a continuance of the preliminary hearing. And if that happens, what that means is that the county prosecutor is presenting your case to a grand jury before the next court date. So when you show up for your preliminary hearing, that court has already lost jurisdiction for your case because you've already been indicted downtown. That's what happens in Cuyahoga County. In Lake County, you actually do get a preliminary hearing, but again, if you want a piece of that evidence and you want a nice low bond, you should waive. The only reason I would ever consider not waiving a preliminary hearing is if you have a drug case that involves a traffic stop where your car was searched, or where your house was searched, or where your person was searched. And the officer testifying is the person who found the drugs, the guns, or other types of contraband. The reason I would hold a hearing in those situations is because a lot of times you can lock those officers into statements where they're under oath and they think they know the law, but often don't, and may admit to constitutional violations that you can use against them later on down the line in county court. Other than that, preliminary hearings are fairly useless, and our general advice is to waive them. If you have any further questions, feel free to give us a call in the office or go through the frequently asked questions tab sent through the link. Thanks.
Sam White. We fight